And now, it's The Law Show on CL 650. A comprehensive look at everything you need to know about the law.
Oh yeah, Stevie Wonder, signed, sealed, delivered on The Law Show today, and it's fitting because we're talking about wills today. And in this show, we're going to be talking about what the trustee and what the executor of the will would have to do once somebody has passed away. And joining us today on The Law Show from Lakes White in North Vancouver, we have John Lakes and John White, partners. And we're talking about the basic rules of executing a will. So this is... you know, the will has been written properly, hopefully here, and you have an executor is going to go through dispersing the monies as you go through. So what is that called, John, when that person has to do that job over a couple of years?
Well, once someone has died, then you apply for probate, which is where the courts legally recognize the validity of the person's will, and then they appoint the person named as the executor to have the legal right to carry out the terms of the will and carry out the legal obligations of the deceased person. So it is necessary to wind up their estate and deal with their property and deal with their debts.
So that's the sort of like the legal green light to move forward, right?
That's correct. And so it's like once you get letters probate issued, it's like getting to first base. There's a lot of work to do after that.
And we're going to go through those steps and what has to be done. Now, this is all contingent on the fact that it's been done properly, and why we played signed, sealed, delivered off the top is that we'll talk a little bit about the actual signing of a will and how important that is, but we're kind of going through this process and the fact that it has been done properly. So one of the things that we want to talk about is you know, what are the first steps when you have to start paying people out? I would guess government always comes first, right?
Well, first of all, you have to determine what the person has as assets. So in the will, for example, they may say, I leave my green teapot to Mary and my diamond ring to George. And so you deal with specific things that may have been left in the will to specific people. And then after that, you then have to deal with the various assets. So, and normally in a will then creates an obligation to you to convert those items into cash, which means paying the items out or postponing them as well. So, for example, let's say the person when they've died, they have a GIC in their name they get 5% if they hold it till the 2018. It could be that the executor has the right to not convert that into cash right away. They can delay that.
Well, could that be the case in this hot real estate market, or is that just speculation
at
that point?
Well, the problem with real estate is that real estate is an expensive thing to hold because you have taxes, you've got insurance, you've got certain liabilities and so forth. So generally when someone has been named an executor, they have like a year to deal with these things. So if you're acting if there's some real estate involved and you're an executor, then their obligation is to get a top value dollar for the property. So first of all, I always tell my clients they should hire a real estate agent. Second of all, they should tell the real estate agent that they cannot double in the transaction.
Right.
And what that means is, for some reason, real estate agents can act for both a purchaser and a vendor of the same property, which to me is a built-in conflict of interest. Because I don't know how you can say to the buyer, well, this is the best price I can get for you, and at the same time to the seller saying, well, this is the best price I can get to you. Right. So with somebody who's trying to sell property as a executor, it's important that they get top value, their agent is not in a conflict of interest, and that they pay the standard commission. But they don't have to sell it right away. They don't have to have a garage sale. They need to do it within a reasonable time, and they have to act in a prudent manner.
Well, that point is probably the most important of all. The fact that executors generally have to act in accordance with a person of ordinary prudence in managing their own affairs. And I think we've talked in a past show about situations where executors don't do that. They either hold on to the real estate too long, or they try and do things with the real estate like subdivisions that they're not qualified or experienced to do. They cause a loss to the estate and to the beneficiaries of the estate, and the courts visit that loss on them.
Mm-hmm.
And even our most important case on executors' liability or executors' duties from the Supreme Court of Canada, the Fales case, is an example of that, where essentially it's about shares, not real estate, but an institutional executor holds on to those shares for way too long. They tank in value. The estate loses a lot of money, and they're held accountable ultimately by the Supreme Court of Canada.
So somebody held on to Nortel shares for
Yeah.
too long, right?
If you, I mean, a lot of people who thought they were prudent held on to Nortel shares. I mean, it's not, just the fact of holding on to Nortel shares when they turn out to be disastrous, that's a problem. But, if you know, or you should know, that Nortel is going to tank, and you're the executor of an estate which holds those kind of shares, you should not be holding on to those shares. You need to act in accordance with the standard of ordinary prudence, or you can be personally liable.
So is it better to be timely in these things and just wrap it up?
Well, you see, first of all, it depends on what powers you have, because there may be some special provisions in the will to allow people to postpone. But sometimes there's strange situations. So, for example, you might be living in a residential neighborhood that's two minutes from a SkyTrain station. Right now, your house is assessed at $1.2 million. However, there's somebody trying to assemble the land, and if they keep the whole property for another year and it's rezoned, all of a sudden you're going to get $2.5 million.
Like all those houses down Canby Street.
Yeah,
right?
or there's just been something like that in North End. So if you're a proper executor, then you may actually go to the beneficiaries and say, look, this is the guy, we can either do it now, or if I get my permission from you, we'll hold it off for a year and we'll rent the houses out. So as an executor, you have an obligation to act prudently, but you also have an obligation to communicate with the people that are affected. So if Mary says, well, great, I can wait a year and I'd rather get $500,000 more, I'll do so. But eventually these assets have to be converted into cash, and you have to act in a prudent manner. Cars are always difficult because you're trying to sell them maybe through Craigslist or whatever, but because eventually when you're an executor trustee, you have to do an accounting. So you have to clarify and justify to the beneficiaries what you've done and how you've got it. So, and I don't want to talk too much because there's been a lot of talk about real estate, but I mean, the other thing I usually tell to my clients is that if they're going to sell the property, they make sure that there's a no flipping clause in it as well. So all of a sudden they go ahead and sell the property and find out that they're not selling it to Mary Jones, but they're selling it to Frank Smith, and all of a sudden they're only getting now selling for 1.7, but they still only get 1.5, and somebody gets 200,000 for nothing.
Well, the inverse of that, of saying somebody who goes in and subdivides a lot and they're in over their head and they lose money, they're on the hook for this. Now, somebody who's has a house on an area that's been zoned for commercial use, and if they waited a year, they would have been able to double their money, for example, and they sell it before that point, are they also on the hook for that?
Well, I think it depends on the circumstances. I mean, we go back to the point that the standard is to be of a person of ordinary prudence. You don't have to be a person of superhuman prudence.
Right. Or an expert in anything. Right?
You don't have to be right all the time, because people of ordinary prudence aren't right all the time. But what John said a moment ago makes a lot of sense. Communication is something that you would expect of a person of ordinary prudence. You'd expect such a person to seek professional advice, and the professionals don't always get it wrong. Even lawyers don't always get it right.
No.
We try not to talk about those situations too often. But if you're a person of ordinary prudence and you don't know the field, like the real estate field or the stock market, then surely a person of ordinary prudence would go ask somebody who does know.
Right.
A prudent person, I think, would also take up John's advice and talk with the beneficiaries that you're supposed to be acting in the interests of, and take their views. If your accounts as executor are going to come under scrutiny at the end of the administration of the estate, you're in a much better position if you have essentially talked to the people who are going to be approving or not approving your accounts in advance. And if your answer, if there is some sort of a loss, is, but this is what you told me to do, that's not a bad answer.
All right. Now, what about, we talked about real estate. Now we've got to pay the bills.
Yeah, I just want to talk a little bit more about
Okay, yeah,
these
go ahead.
things. So there may be other powers. So, for example, there may be the rights to take out mortgages and delay purchase of mortgages and things like that too. So it's just they have to, at some point, these assets have to be dealt with, and they can hire people to assist them. And they just have to, and they cannot be, the other thing is they cannot be in a conflict of interest. So if you're the executor, you can't hire your wife to be the real estate agent either. So you have to, you're in a position of a trust to everybody else. So you have to operate with clean hands and not in a conflict of interest.
No, it's a good point. Having a direct financial stake in how the estate is administered when you're executor, that is just something that's going to lead to trouble. And executors have been held liable in those circumstances, especially where there has been a loss as well. They've allowed their own financial stake to cloud their better judgment as to what they should be doing. You should not do that as an executor.
But often you have an executor that is a family member, and often wills will impact that person, right? In some way or another. Like they might be the husband of a child, and their wife is going to be getting some money. So how do you keep it clean?
Well, don't hire your own company to do work on behalf of the estate would be a good example.
Right.
I'm thinking of this sort of failed subdivision case that we talked about a couple of shows ago, where the executor tried to subdivide a property, a rural property, that he really didn't have the qualifications to do. But one of the things this guy did was he had his own company, and his own company did a lot of the work, and he billed for his own company's work. His own company billed the estate. I mean, it was a conflict of interest, an obvious conflict of interest. You can't do that. I mean, that's an order of magnitude different from just the fact that you're going to have to deal with your family members if you're an executor as often as not.
But on the other hand, if you're an accountant and you've been doing your mother's accounts for 20 years and you're also the executor, and as long as the other beneficiaries are okay about it, you might be the logical person to act not just as the executor but also as the estate accountant as well.
Well, sometimes wills will have a specific provision in them that permit a professional person who's acting as executor to charge their professional fees.
A standard rate,
at their regular hourly rate. And I would think it would be a good idea, if that's what you want to have happen with your estate, put it in your will.
Well, it's good that you talked about accountants, because we're after the break going to talk about bills and paying the bills and who has to get paid and how that's done. So we're on the Law Show today talking about the basic rules when it comes to executing a will. Joining us today are the two experts, John Lakes and John White from LakesWhyteLLP in North Vancouver, and we'll pick it up with that next here on the Law Show.
There's more of the show still ahead. This is The Law Show on CL 650.